I think the fundamental flaw in this case is its reliance on the First Amendment and freedom of speech. While the First Amendment doesn't apply because Congress did not make this law, the Constitution of Colorado sure does. No law shall be passed impairing the freedom of speech. Every person shall be free to speak, write, or publish whatever he will on any subject, being responsible for all abuse of that liberty. Again, I think the free speech argument has a fundamental flaw, one that was exposed under Skrmetti. The state is attempting to regulate treatment, not merely speech. But as I mentioned, just because the First Amendment and free speech aren't the issue, that doesn't mean that there isn't a constitutional violation in Colorado's law, specifically due process. From the 14th Amendment we read, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law." You see, Colorado has passed a law that not only deprives Ms. Chiles of the liberty to practice her trade, but deprives her clients of a desired treatment. Now, this would be allowable if Colorado had followed due process, which is defined in the Free Legal Dictionary as an established course for judicial proceedings or other governmental activities designed to safeguard the legal rights of the individual. See, in this case, that would mean showing that the treatment banned by law was actually harmful. And remember, the state has the burden of proof, not the individual, as Mr. Campbell pointed out under Justice Jackson's questioning.
Our expert materials also recognize that they cannot prove harm. We've cataloged all the places in their expert materials on page 22 of our reply brief where they concede that. And lastly, their own expert materials recognize that many people have experienced life-changing benefits from this kind of counseling. Again, the APA's own report talks about how this helps people because they're able to align their life with their religion. They're able to find deeper relationships with God. They're able
Doesn't
to
Colorado have some evidence that conversion therapy more broadly is harmful? I think there are like 25 states or something who have similar laws. So someone has some evidence related to the harmfulness of this activity, right?
Colorado certainly cites studies, but those studies suffer from significant flaws. The main flaw in all of them is that they lump together dissimilar approaches. They treat voluntary conversations the same as shock therapy.
This topic was also brought up by Justice Sotomayor in her questioning of Mr. Mupin.
The thing that gives me pause in not applying strict scrutiny or in applying it is that none of the studies say that talk therapy is harmful. Is that correct?
Justice Barrett gave Ms. Stevenson the opportunity to answer that question.
What is your best evidence on this record, thinking about the application of strict scrutiny, that this kind of talk therapy by a licensed therapists to minors causes harm?
Sure. I would direct you, Your Honor, to JA 64 through 74. And I do want to note this particular argument about this specific study came up for the first time at 10th Circuit oral argument. And I think had we had an opportunity, we could absolutely have put in even more evidence to nail this down in the district court. But if you look there, our expert walks through all of the research that's been done since 2009. Aversive practices have not been in use since the 1980s or before, so all of these studies do not concern aversive practices at all. And then I would direct you specifically to the Green study and the Turbin study. The Green study looked at 34,000 13 to 25-year-olds who had gone through conversion therapy, and after controlling for other factors, found there was a 2 times rate of attempted suicides among that group. And in the Turbin study, Dr. Turbin looked at 27,000 participants. This was specifically on gender identity change efforts, including people who had received those efforts at under the age of 10. He looked specifically at childhood exposure and found association with adverse mental health outcomes in adulthood, including suicide ideation and attempts.
That all sounds pretty good until we look at Mr. Mupin's response to Justice Sotomayor.
For talk therapy by a licensed therapist to minors, they don't have any studies that say that is either harmful or ineffective. And indeed, they often concede that they don't have that. The 2009 APA report expressly acknowledges at pages JA 221 and 256, expressly acknowledges that they don't have evidence of that. And if you look at the Glass-Gold Declaration, which is after 2009, she too doesn't cite anything. If you look at the studies that she cites in her declaration, all of them are conflating either aversive and non-aversive, or licensed and non-licensed, or minors or adults. They just don't have anything.
Except according to Mr. Campbell in his rebuttal.
On the issue of studies, there was a reference to the Green and Turbin studies. All of those studies relied on bias sampling, self-reporting. They conflated aversive techniques with voluntary counseling. They did not isolate licensed counselors, and they did not purport, even in their own study, to prove causation.
So is it the quantity of studies or the quality of those studies that provides proof of harm? As Justice Barrett reminded Ms. Stevenson, she has the burden of proof, not Ms. Chiles.
But you bore the burden. She didn't have to show that it was efficacious, right? You had to show that it caused harm.
Right, but in light of 100 years of studies that all point in the same direction with no efficaciousness and evidence of significant risk of harm, we think we amply carried that burden.
So not only did Ms. Stevenson completely ignore the arguments by both Mr. Campbell and Mr. Mupin about the quality of the studies, she also ignored the harm caused by the law, as Mr. Campbell noted.
But one of the things that's so problematic about Colorado's law is that it undermines the well-being of kids that are struggling with gender dysphoria. And so Colorado accepts that up to 90% of kids who struggle with that before puberty will work their way through it and realign their identity with their sex. But this law says that if any of those children go to a licensed professional and say, I would like help realigning my identity with my sex, that licensed professional has to decline to help them.
If 90% of children who struggle with gender dysphoria work through it and realign their identity with their sex, isn't preventing them from seeking help to do so harmful? Thereby, they are denying these children the liberty to seek treatment, not because it is harmful or ineffective, but because it does not align with the political views of the state.